Well, good afternoon and welcome to another episode of Ask Two Lawyers. And I think we're probably the last content creators to come on and talk about the sweeping court order from today, Judge Liman's order. But before we do that, Stuart, how are you doing?
I'm doing good. How about yourself?
I'm doing good. And we have Eric with us, and Eric is not in studio. What state are you in exactly, Eric, besides the state of confusion?
Undisclosed location.
Okay, that's
New
good.
New England, East Coast.
Okay, so he's getting away. But we appreciate you taking time out of your time there in New England to join us today. Thank you.
No, of course, I was excited, and glad it'll work out this way with our audio and pulling up comments and everything. But no,
it's always better to have you along, and you keep us on track. So thank you for that, Eric.
Thanks.
It's a big day, and this is a big order that came out today. And before we really get into the nitty gritty about it. You and I, Stuart, were talking a lot just about what are the parties feeling? What's the Baldoni camp feeling right now? Their lawyers. What's the Lively camp feeling? Kind of fill us in on what's happening here on either side.
So, Keith, you and I have worked years, 2-3 years on cases, and we've gone to trial, and we've lost those cases. We don't lose many cases, but we do lose cases. We've also lost motions that we've worked really hard on, and the feeling that you have when you lose, especially on this scale, and this is a gut punch from this judge. Every cause of action is dismissed. 2 can be refiled, only 2, not more, without court leave. And they're kind of, in my mind, throwaway breach of contract type actions. I'm not even sure that Baldoni's team will do an amended complaint. They might, but I want to say that I feel sympathy for Brian Friedman and his team today, for Justin Baldoni and the Wayfair parties. This is a tough day in litigation, and the hurt that you get from a ruling like this, it's devastating, it's crushing. And I know as a lawyer, there's times where, I lost a case one time that had to do with wrongful death, and we weren't able to recover damages for somebody that had passed away wrongfully, in our opinion. And I couldn't sleep for like 6 weeks. And so my sympathies are very much with the Wayfair and the Baldoni crew and their lawyers. As far as Blake Lively's lawyers go, I think there's some people that will envision that they are rejoicing, like at a Super Bowl win or a World Series win or something like that. They're not, in my opinion, they're not. They're just relieved. They're relieved big. I mean, it's kind of like, it's not as bad as it hurts to feel. It doesn't feel as good to win, but it's just kind of this, oh, wow, we really won on this one. I mean, they're happy about it, no doubt, but it's more of, all this blood, sweat, and tears by both legal teams up to this point in time. They have worked hours and hours, late nights, early mornings. They're constantly, they're skipping meals. Many lawyers lose weight during this time because they just don't eat. They're just constantly working. And so the feeling on the Baldoni team is rough, and it takes several weeks to get through something like this and process it. The feeling on the Lively team is just more of a relief. And also, now you're in a position that you feel good that you had this great win. And this was a significant win, in my opinion. Now they're going to sit down and figure out what are their next steps. I mean, the judge invited everybody to refile their request for attorney's fees. So that'll have to be revisited. 47.1 is still an issue. That's still going to be hanging over Baldoni and the Wayfair parties. And what does Blake Lively do with that? Does she actually go forward on 47.1? Even though the court didn't make a ruling specifically on 47.1, she still is what we would call the prevailing party. So those are the things that people are just starting to gently think about, but more really the feelings that both sides are having today. One is relief, and the other is just despair.
It is funny because we've lost motions or whatever, where you put your heart and soul into them. When you lose, it's absolutely devastating. When you win, you're like, oh, that's a little bit of a relief.
Right.
And it's never like a huge, it's funny how it works. But this was a big loss for Baldoni. There's no doubt about it. Before we get into the nitty gritty, there's one other thing I want to say. I want to say that I am very proud of what we've done on this channel. I'm proud of you, Stuart. I'm proud of you, Eric. I'm proud of what we've accomplished here because we've stuck to our guns and we have come to people and to our jury pool and we have given you our honest analysis of the law as we see it. And there's always room to argue. Different lawyers will have different opinions, but we've done our best to give you our legal analysis as we see the case and as we see things unfolding. And, unfortunately, we've, for whatever reason, gotten a lot of hate and a lot of backlash. And there's been a lot of hate against you in particular, Stuart. And I don't think it's fair. I don't think it's right. But that's fine. I mean, everybody's entitled to their opinion, and we're not going to change. We're not going to stop doing what we do. This is what we do, and I'm glad we do it, and I'm glad we do it this way. So, but we're not sitting here, we're not happy about what happened for the Baldoni side either. I mean, to be honest, we did see some of this coming. We did warn about a number of these issues coming to light. And so it's not a complete surprise to us that it's happened, but it is a more sweeping order than even I would have predicted. Would you agree with that?
It is. And first of all, thank you for your comments, Keith. I will say that you and I are human beings. We're pretty thick-skinned as trial lawyers. But, the comments do catch up to you. And, if I could make one request that we all, including myself, where we have strayed in our views on this case, that if we could all treat each other with a little bit of respect. I'm not lecturing anybody. I'm talking to myself more than anybody. Let's at least disagree, as friends and neighbors, and try not to give the worst attributes to the people we disagree with. I just because you disagree with me on something, Keith, I don't think you're unethical. And producer Eric, I don't think you're unethical. I don't think you're a bad guy. I think your name got dragged into this, unfortunately, last time we talked. And I don't, I want you to know, Eric, I only have wonderful thoughts about you. And I think that you and I have a good relationship around the office. I didn't know. I haven't asked you to say anything. I don't know if you want to say anything. You don't have to, but do you want to say anything, or do you want to comment on any of the comments that you saw?
Yeah, I echo, what you guys had said. I was shocked, honestly, because I thought we had a really great episode. We all wrapped up on Friday, and we're kind of laughing, and that's how it works. Is we see how the video goes. We look at the YouTube studio in the back end. We're like, oh wow, we're getting all these views and stuff like that. Clock out, kind of leave that at the office, go amongst our weekend and stuff. I had a very nice time doing Korean karaoke, like in one of those private rooms with some friends, like that Friday. And I was like, wow, this is what life is really about. Just kind of belting out all this stuff and kind of forgetting what you might, and leaving any hate or anything like things like that at the door. And then kind of see all these comments on Saturday, and we were shocked. But no one needs to stick up for me. This was really odd to see, and I don't know. The only thing I wish is that I could think a little bit quicker and then ask Stuart, if he had met, because I still don't know actually if you had met any of these parties. So that's the only thing. But our relationship, like I wrote, goes beyond these microphones and stuff like that. And it's a tough dynamic. Like I understand if people were to record you and your best friends and stuff having a conversation, it might look a little off. So. But the comments do make me sad sometimes when I see unnecessary hate towards Stuart. So it makes me sad. I'll say that much.
I think I can speak for Stuart when I say this, that we both very much appreciate everything you do for us, Eric. And this podcast wouldn't be possible without you. So, anybody who thinks otherwise or we think otherwise, that's certainly not true.
It's pretty ridiculous, to be honest. But yeah. We can leave it at that.
Appreciate your comment, Eric. So let's dig into this. I mean, Keith, obviously, on a scale from 1 to 10, how bad is this for the Baldoni Wayfarer crew?
Well, let's go back to our case 1, case 2 graphic, because I'm always coming back to this. So when it comes to case 2, this was Baldoni's countersuit against Lively. It's pretty much gutted. It's gone. There are 2 causes of action that Baldoni can try and save by filing an amended complaint. That's the tortious interference with contract and breach of implied covenant. In my opinion, those are probably his 2 smaller claims out of the whole complaint, but those in theory could be salvageable if they choose to do it. Now, case 1, keep in mind, that's the original sexual harassment lawsuit by Lively against Baldoni. This order does not affect case 1. So Baldoni has not been harmed in his ability to defend against that sexual harassment lawsuit. He has every right to do that. This order will not affect that part of it. But in terms of case 2, it's pretty much gone.
Case 2 is pretty much gone. And I will say, if Brian Friedman, after he comes up for air a week from now, 2 weeks from now, because this is a devastating gut punch, I think that maybe this could turn out to be a refocusing of the case. And basically marshaling the troops again and talking about what your goals are going to be. And now you can truly focus in on the case that I've said all along, and I think you have as well, Keith, is where he can defend himself against the sexual harassment claims. And there's a lot of evidence. The court here did not review Exhibit A in coming to its determination. It did say it wasn't going to strike it, but it didn't review Exhibit A. But Exhibit A has a lot of evidence in it. People call it receipts, and there's other pieces of evidence. But I want to say again, let's not get caught up in the idea, at least this is my humble opinion, of saying that this case is overwhelmingly on Justin Baldoni's side. Blake Lively has good lawyers, and Justin Baldoni has good lawyers. And that means both sides are going to be coming up with very good legal theories and moving this case forward. It's my hope, Keith, that this type of devastating loss would lead both sides to getting together and having those settlement discussions we've been talking about.
Yeah, I think so. I mean, now's the time. They've each kind of they've drawn their positions. They've each, gotten a few things. Lively's withdrawn.
Withdrawn is a good word. I like it.
Sorry, guys.
I nominated for Oxford English Dictionary Word of the Year.
Yeah, thank you. They do change the dictionary every now and again. Lively has withdrawn her intentional infliction claims. Baldoni now has suffered a pretty big defeat in his counterclaim, his case 2.
Right.
Now would be the time to get together and talk, I think. But there are a couple of highlights I want to point out in terms of the court's order. So first of all, governing law. Remember how we were talking about...
Do you want me to pull up the order or not? I don't have to if you don't want me to.
Yeah, you don't have to. I think we'll just
discuss it.
Okay. It's a huge... it's 132 pages, so it's a lot. But governing law, we were talking about what law is going to apply. The court applied California law relative to Lively because the court said, well, Baldoni brought his lawsuit against Lively using California causes of action. Lively agreed that California law applies, so California. For Reynolds and Sloan, the court said, well, I can't really determine which state should apply to them because there wasn't enough facts alleged in the complaint to make that determination. So I'm going to apply California law as opposed to New York, unless, at some point, things change. But California applied to Reynolds and Sloan. And then the New York Times, they applied New York law. And so that was the analysis. And it was a pretty long analysis that the court did to get to those conclusions. But that's the result that ultimately the judge went with.
Can I just kind of try to pull this all together? I mean, basically all motions to dismiss that were filed, and that's by Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR, and the New York Times, they were all granted.
All granted.
And the amended complaint filed by Wayfair and Baldoni was dismissed in its entirety.
Yes.
Okay. And then the motion to strike Exhibit A, that was denied, but the court said, look, I didn't use it. And then the real issue that I think we're going to talk about, and I don't want to get in your way here, but the real issue we'll get to is the attorney's fees under the anti-SLAPP statute vis-a-vis Reynolds and Sloan. And then you've got the 47.1 damages for Lively. Did I capture kind of the nutshell there?
I think so.
Okay.
I think that's the key. And I think the only thing I wanted to point out was I think the big issues in my mind were the defamation issues. So yeah, they pled civil extortion, that's out. They pled false light, that's out. As far as defamation is concerned, so why was there not defamation against by Baldoni against Lively? And it really came down to Civil Code Section 47D.
Not 47.1.
Not 47.1, 47D. And you could kind of see why, because
that's that's not the litigation privilege. That is the what?
Fair reporting privilege.
Fair reporting privilege. Okay.
It is part of the litigation privilege, but it's a subsection that covers the fair reporting privilege. And the court said, well, as far as the court was concerned, the only thing that was reported to the New York Times was the CRD complaint. And yes, there was texts and emails, but that all was kind of part and parcel of the CRD complaint. And so under 47D, that would be privileged from a defamation lawsuit. And for that reason, the judge really didn't need to go any further. He kind of got to that point and stopped because that's all you need. And so 47.1 was not decided on, although it's an open issue, and we'll talk about that when we get to fees in a minute.
Right.
Then the next question is, why not defamation against Ryan Reynolds? Because that one actually seemed pretty good to us.
I thought it was a good claim, and I thought it could have been fixed with an amended, like a second amended complaint by Baldoni and Wayfair. But the court here basically says, I can make this determination right now. I'm not going to leave it to a jury. And if you remember, Keith, we've spent a lot of time talking about how you leave factual determinations to juries and you leave legal determinations to courts. And I think other lawyers that have been commenting on this case have talked about that a lot in relation to 47.1 and other areas. But the court here says, I don't need to really, I'm not really making a factual determination because I can look at the complaint and what did the court say about that?
The court said that there wasn't any allegations that would go to malice. And malice, remember, is an understanding. You have to think in your mind that what you're saying is false when you're suing a public figure, which is the case here. And there's two different standards, because when you're suing a private figure, you don't have to do that. But when you're suing a public figure, you have to take an added step, which is very difficult to win on. That's why public figures, it's very hard for a public figure to sue and successfully for defamation.
Right.
And the judge said, well, at the time that Ryan Reynolds said what he said, he wasn't there. He didn't see whatever. He wasn't on the movie set seeing what's going on. So he just was parroting what his wife told him, Blake Lively. And so if he's saying things that, yes, even if they're inaccurate, let's just say for a moment that what he's saying it's not truthful, but in his mind, he doesn't know it to be false.
Right.
Then it's not enough.
Where's the malice?
There's no malice. And so the judge said that's just not enough to get past the standard for defamation against Ryan Reynolds. So that one's out. And then why not
this? Oh, sorry. I was just going to say, coming back to this question, if you want to put this together, did Baldoni's team make a mistake by not amending their claims the first opportunity they had? Is that what you were saying, Stuart, or am I off base?
I think they could have amended to clean up some of these issues, but my opinion on this, Eric, and I'm interested what yours is, Keith, is they shouldn't have brought the defamation claim and the other causes of action to begin with, so that they could have focused in on the case number one and focused in on all the good evidence they had in this case and really been leveraged in their arguments and leveraged in how they pushed the case forward. But instead, they bit off more than they could chew, in my opinion, in filing the defamation claim and the other causes of action, which has taken up a whole lot of energy, time, attorney's fees, and now put Justin Baldoni and his the other parties on his side in a bad way regarding 47.1 damages. So I don't think it should have been filed at all. But Eric, in answer to your question, I think they could have cleaned it up, especially as to Ryan Reynolds. And I do think if you could have cleaned it up as to Ryan Reynolds, it is hard to prove malice against a public figure. But there are certain words that do rise to that level. But for whatever reason, I think Brian Friedman thought that if the court ruled against him, he would give him another bite at the apple.
Yeah.
And the court did to some extent, because he gave him the two probably least good causes of action that were left. And Brian Friedman's going, oh, that was a mistake. But again, I think Brian Friedman at the end of the day here, it's going to be better for Brian Friedman, because now he can, like a laser, he can focus in on defending his client, which is where I think he should have been all along.
Well, that's interesting, because if you hadn't have filed these claims, then you wouldn't have given Lively kind of this win.
Yes,
because you would have just been defending.
Right.
But it's hard to say too. I think that they should have filed an amended complaint. I was surprised they didn't do it at the time. Once you saw the briefing come in from the different parties, I think I would have amended the complaint and at least tried. And maybe you wouldn't have been successful, but I think I would have at least tried to do it.
Yeah, I think we had it, because I remember making the short about it some time ago, and yeah, you guys were kind of like, hey, let's focus the firepower, so that makes sense. But I was kind of surprised about the Reynolds thing too, and this is a comment from Ellie. He was on set. There's all those photos of Reynolds on set. So yeah, I'm kind of surprised.
But they didn't have it apparently alleged properly. Remember, you can only focus. The judge only looks what's in the pleadings, and so that's the problem, is what's in the allegations. Now, yeah, I guess I am a little surprised that the judge didn't say, well, as to Ryan Reynolds, I'm going to let you amend.
Yeah, because that basically that cause of action is done. It's over.
Yeah. And that's why this order went even further than I would have expected. I mean, we were anticipating some of these things, but I don't think we anticipated all of them.
That's accurate.
What about the defamation against Times? Why was there no defamation against Time, the New York Times? Fair reporting privilege. It comes back. And, essentially what they're saying is that there's nothing in the information that was given to the Times that would lead the Times to believe that it was knowingly false, or they were publishing something they knew to be false. And again, this is because you're publishing something about a public figure. And so the standard is much higher. You have to hit that malice standard.
So the thing that surprised me most here is that the judge, that's another word.
Now you're doing it.
The judge decided these 12b6s all in one order,
Yeah.
which was interesting to me. And I just kind of anticipated that the New York Times 12b6 would come out and it'd be granted in their favor.
That wasn't that surprising.
I felt like that would happen, but to have all of these come at one time and to be all pretty much, you're done. These causes of action are done. You can do these amendments. I've heard several people talking about, several content creators talking about how, well, you can not only amend as to the 2 causes of action the judge allowed you to, but you can bring in the Taylor Swift stuff now. You can bring in, the spoliation of evidence. You can bring in the Van Zandt stuff. And according to the court's order, and I'll ask you, can you bring in new causes of action at this point in time in the case?
No. So the judge said you can only amend the allegations relevant to tortious interference with contract and breach of implied covenant. If you want to bring in some other cause of action or claim, you would have to get court permission to do that. And it's unlikely the court would give permission, but that's what you'd have to do.
Something else I've heard reported today by several people is that this really isn't a bad decision. And this really, there's a silver lining
for Baldoni.
Baldoni. And that this all really going to be is a good thing at the end of the day. Do you agree with that assessment?
It's a bad decision in terms of his counterclaim. It guts his counterclaim. So yeah, it's bad for Baldoni in that sense.
Is there anything good that came out of the court's order here for Baldoni?
I think just your view of the case, which is it helps streamline the case for Baldoni so he can really put his firepower where it counts, which is defending against the sexual harassment claims.
Case number 1.
Case 1. And so he can put all of his efforts in case 1, which is probably where it should have been in the first place. I think that could be a benefit to Baldoni, believe it or not.
I have another question for you, and not gloating here, but I'm curious about your response to this. For the last couple months, there's been a lot of people talking about 47.1 and how, the 12b6s, the motions to dismiss here, are just going to be routinely, disposed of, and the case is going to end up going to a jury trial. Well, obviously, the case number 2 is gutted and gone. There was lots of lawyers that weren't concerned about, the 12b6s here. What's your response to that? Is that just, lawyers are going to see this differently at times, and sometimes you're going to be right and sometimes you're going to be wrong?
Well, that's a big part of it. I also think that it is rare that cases are out and out dismissed at this stage. It's not a common thing. But and then the third thing I would say is that this whole 47.1 is so brand new. Like nobody knows it. I mean, this is literally the first case to deal with it. And even this judge is like, well, I don't need it. I only need 47D, so I'm going to rule on that. And I'm not going to rule on 47.1. But he kept the door open. So he kept the door open on the fees.
We have a few minutes before some guests are apparently going to be joining us, but let's talk about that last point you made, and that is the damages here. And, is Blake Lively a prevailing party under 47.1? And if so, does she get treble damages? Does she get punitive damages? Does she get her attorney's fees?
So here's what's going to happen. So Reynolds, Sloan, and Vision PR all asked for attorney fees under New York's anti-SLAPP. And of course, Lively asked for damages under 47.1. So the court denied all those motions without prejudice, which means they can refile them. And the reason I think the judge did that is, why don't you refile your fee request with my order in mind? And I want you to brief it. And he actually said, if the defendants choose to renew their motions, they shall fully brief the impact of this opinion that I'm ruling on now, as well as the issues raised in prior briefings. So keep all of this in mind when you come back to me. But the Reynolds, Sloan, and Vision PR people can come back and ask for attorney's fees for anti-SLAPP. And Blake Lively can file a motion asking for all the damages that are entitled to under 47.1. Now, the court said, I haven't ruled on whether Lively's statements were privileged under 47.1 yet, but that doesn't mean he couldn't. And if you think about the breadth of it, you want to talk about that?
No, well, it's just, I think you made the point. I want you to talk about it, just the narrowness of 47 and the breadth of 47.1.
Yeah, so 47 is a litigation privilege, so it covers anything you file in court. 47D is a fair reporting privilege, so anything you file in court or about to file in court that you give to the media. So the world of 47 and 47D is about that big. The world of 47.1 is about that big. It's any communication that you make about a sexual harassment incident, whether you filed in court or not. And so if your filing in the CRD is a communication regarding an incident of sexual harassment, which it clearly is, then not only does 47D cover it, but clearly the umbrella of 47.1 covers it too. And so I think what you're going to see is you're going to see Lively filing a motion saying that 47.1 was implicated here. and asking for all of those damages that she wants because of that. And I don't know if the court gives her that or not. We'll have to see once we see the briefing, but it's coming. That's what's coming next.
So if we weren't dealing with a federal court judge and we were dealing with a state court judge, I feel like the state court judge would make a finding on 47 B or D, and then they'd split the baby by essentially when the fees request came in, they would deny it and say, I'm not going to grant it because 47.1 is not something I ruled on, and take me up on appeal if you want.
And why would a judge do that?
Because he or she doesn't feel right about hitting Baldoni up with, this is going to be clearly millions and millions and millions of dollars in attorney's fees. And let's just say that, Blake Lively can attribute, call it $5 million to the 47.1 issues in this case, the defamation claim and so forth. Well, if you treble damaged the attorney's fees, which we're not clear how the statute requires them to do treble damages, but let's just assume it's whatever she's out in attorney's fees initially. Well, first she's going to get her attorney's fees back of $5 million.
Yeah.
And then the trebles would be multiplying that by 3, so that'd be $15 million. And then you potentially have punitive damages, which I don't see punitive damages here, but you never know. A court could. And then the question is there some type of emotional damage remedy that comes with the 47.1? I don't think any of us know. I don't think it does, but you would raise the fact that it's something that could be compensated under 47.1.
Yeah, and I think it is, and I think the problem that most judges see when they start handing out fee awards like that are just that massive is it really creates a huge stumbling block for settling, because once you force one party to pay millions of dollars in fees to another party, they don't feel like settling.
Yeah.
They really get, kind of dig their heels in. And you can see why. I mean, that's a huge, hammer over the head.
Right.
So I could see the judge deciding not to enforce that, just in the hopes that maybe it keeps the parties in a space where settlement's possible. But on the other hand, the judge could say, well, that's just the way it is. I mean, this is another example of just how federal court judges do not mess around. I mean, this is a very definitive order. It's a sweeping order, and it gutted Baldoni's countersuit, no doubt.
Yeah. One thing the judge could do also, Keith, is take all of the briefing in on the 47.1 and the anti-SLAPP and say, I'll make my determination after the trial. Now that'd be harsh to both parties, but it would leave both parties wondering if they were going to win that or not, right?
You see judges do that too. Explain what that is, though. How does that work?
What do you mean?
Well, so what would a judge do in that instance? Like, for people who aren't lawyers, what would just take it under advisement? What would they do?
Yeah. I'm taking this under advisement, and I'm just giving the parties notice that more than likely I'll rule on this after we have the trial. And I think part of that is to determine who wins at the trial, right?
Yeah.
And so it would be kind of harsh if Justin Baldoni is successful in his defamation, in defending himself against the sexual harassment claim. I could see a judge going, boy, that's kind of harsh to nail him with
on 47.1
damages. Although under the statute, it looks like the court could if it wanted to.
Yeah, and judges literally will do that. You'll file a motion, and they'll say, rather than ruling on it now, I'm going to tuck this away.
Yeah,
put it in the back of the file cabinet.
Right.
And we'll revisit it after trial.
Well, and again, Keith, we've talked about this since January when we first started talking about this case. These parties need to settle this case. And I know everyone says, justice for Justin, and, we want to have a vindication of him. As you hopefully are learning, the people that feel that way, you're hopefully learning this is much more complex, and there's a lot of nuance to this. And you're never sure how a judge is going to rule. Because I've heard so many people say there's so much evidence that supports Justin in his defamation claim. There's no way he doesn't win that. Well, now you see that the court actually did say he can't win that. Whether you agree with that or not is that's a different, we can talk about that. But the point is, an independent judge who's supposed to be objective has said, these claims are not going forward in my court.
Well, this is war. And when you're in war, unexpected things happen, and it's chaos. That's where I think as litigators, we're used to living with chaos, because there's never a right answer until you reach the very end.
Right.
So, sometimes you win the battle and you lose the war, and sometimes it's the other way around. But just because, Baldoni's countersuit is clearly gutted, that doesn't mean he's done with this lawsuit.
Not at all.
There's a long way to go, and he has, based on what we've seen so far, he has an excellent defense.
Right. But you could see how the discussions would go between Lively's team and Baldoni's team. Lively's team, let's say they're having a conversation today. Lively's team would say, we've got the upper hand now, and we're going to be bringing damages motions. it could be millions of dollars that you guys are going to owe. Are you sure you don't want to get together and talk? And then Baldoni's team's going to say, yeah, but we have such good evidence to defeat your sexual harassment claim. So they're going to go back and forth. But you and I had suggested maybe 60 days ago that Baldoni, nothing was touching him. Everything was going in his favor. The court of public opinion was going in his favor. The evidence appeared to be in his favor. Blake Lively was not liked, and she still to some degree is not liked by many people. But that was where we thought Baldoni was at his strongest, and had, with hindsight, now the benefit of hindsight, he should have really tried to resolve the case at that time. And maybe they did. We don't know what settlement negotiations have gone on here, but it does seem like they're both at this point fighting pretty hard. It'd be nice to see if they could somebody on both sides get together and start those discussions on how would a settlement look.
And maybe they do now.
And maybe they do because of this. Yeah.
It was a sweeping order, and it's not. I would not have expected the court to completely shut down the counterclaims across the board the way he did. So I would have to think that, and that's us as objective viewers of this case. When you're in the trenches, when you're one of the attorneys and you really believe in your case, it's hard to imagine that you could ever lose this motion.
Right.
So I have to think that the Friedman side is really, it's a punch in the gut a little bit, and just be like, good Lord, I can't believe the judge completely gutted everything.
Right.
And so it is a time to kind of regroup. But again, that's when you don't want to necessarily just run out and do the next thing you can think of. You want to kind of, take a step back. Let's regroup. Let's figure out where we're going to go from here.
Hey, let's I thought this was a good comment from Gwen. It says, isn't the discovery phase the most important to see what we can find? What are your thoughts on that quickly?
Especially now with the defense. I think that's absolutely key when you're defending.
Well, and also I think the thing that the curveball for me on this 47.1 analysis, which again, the court did not come out loud and say, I've decided this on 47.1, but the whole idea behind 47.1 and anti-SLAPP statutes is that there's a determination by the judge prior to discovery happening. And it does, whoever made that comment, when Keith and I first started dealing with anti-SLAPPs, it was always like, but we have evidence to prove this.
Right.
And shouldn't we be able to develop that evidence? And it's like, no, you either have to meet these two-step analysis or whatever the analysis is to get past it right now, or you're done.
It's harsh. Anti-SLAPPs are harsh.
Well, without further ado, we got a couple awesome guests here. We got Lauren and Omar. We got a whole party in here. I might even jump off the screen, but thanks guys for joining us.
Hey, can I just say that I literally am nervous meeting Lauren. Lauren, you don't know how much I watch your show and how much I like you. You are phenomenal, and I love your personality. It is so, what's the word I'm looking for? Infectious. And the reason I wanted to have, and Omar, I really appreciate you. At nighttime when I can't sleep, my girlfriend, she's like, "What are you doing?" I'm like, "I'm going to watch The Tilted Lawyer." But the reason I asked you guys on today is I was watching you earlier today, and Omar and Lauren were talking about how, asked two lawyers, and maybe more specifically me, how I had said some things that they disagreed with. And of course, I do disagree with Lauren. I disagree with Omar. But I also
from time to time.
Yeah, I agree with things they say too. I'm not suggesting I disagree with everything.
No, I always disagree with everything Lauren says.
But the thing I appreciate so much is your guys' comments that, hey, we could be neighbors, we can be friends, we can still disagree. Omar said, I don't give a shit about what Stuart said about, the snake in the grass thing. But he goes, but I can listen to what he has to say. I can be reasonable with him. And Lauren, I know you've had a devastating day. I know you've been traveling too, or going to be traveling. But I know it's been devastating for you, this ruling by the court. It's a gut punch, no doubt. But I wanted you guys on just to show that, look, I'm happy to talk to you. I hope you're happy to talk to me. And I'm happy to have a lively debate about this. And just because we may disagree on a point or two or three, I still have respect for both of you.
Oh, yeah. I like you guys too. Obviously, I'm usually watching when I can. Sometimes I can't always be in the chat, but I'm usually watching you guys. I think that people have come down a little bit harsh on you a couple times, and I felt really bad about that. I was like, oh, that's not fair. So, but yeah, no, it's good to talk to you. I do have to get to the airport in 30 minutes. You're right, but or leave for the airport in 30 minutes, I should say. You're right, but I wanted to pop in while I could. So,
Omar,
just so
nice
you
to
guys
meet
know, it was a pleasure to meet you, sir. Just so you're aware, asked Lauren to be on her best behavior while she's here.
No C words, Lauren.
Yeah.
I volunteered
so,
to be
yeah.
on my best behavior. Thank you very much.
But yeah, so I guess you guys did a show on Friday, and I heard about like the comment, like Lauren's like, hey, Stewart is talking shit about you on their show. I was like, what did he say? And then I listened back to it, was like, he didn't even say anything bad. And like, to your point, look, I don't know everything about this case. I get my opinions. Like the thing I was saying today is like, I've heard most of the comments I get about your show is, hey, Stewart is riling up people again. He's not like fully on Justin Baldoni's side. He's like praising Ezra for this and that. And it's like, hey, listen, he's an objective guy, and he has a certain style and ability to discuss this case in a very objective way. He's been an attorney for 20 plus years. And when you jump on YouTube and everybody's not used to that, and trying to find like the strengths and weaknesses of both sides, it could have the effect of rubbing you the wrong way. I feel like Stewart is being unfairly like become like the punching bag, because you just simply want to look at things objectively, which I never agreed with. Like my whole snake in the grass comment was about the Van Sham thing, which I don't even know all of the details with. And I thought that you had made a poignant statement where if Friedman, he may or may not end up filing something with respect to that and sanctions or whatnot, or maybe he's looked into it and there's really nothing there and he's not going to file anything. I don't know the answer to those questions. Like I can have an opinion about like who people are or the way that they're litigating, while not saying, maybe the snake in the grass comment was a little bit much. I don't know, but it's how I felt at the time. And when you're covering this case, it's hard to ignore your emotions when everybody else around you, your commenters and people that are in the live chat, are so emotional. Like you get caught up in all of that. Except for you two, I feel like you guys have done a really good job. Keith, I think you're harder to read than Stewart at times.
That's
that's like the nature of the yin and the yang of your guys' relationship. But I could, I never fault anybody for having differing opinions from mine. I'm certainly not the smartest guy in the room very often when I go into any room. And so I appreciate
you're alone right now.
I know,
so
unless I'm
that's
alone.
not good.
So let me ask you this, Omar. There were some things in this this order that Stuart and I think were anticipating, but it went beyond even what I anticipated. It was a pretty sweeping order. What were your thoughts? Did it catch you by surprise?
It did. I mean, I thought that they were going to at least allow them to amend the complaints as to fraud and defamation. For him to just completely dismiss, basically with prejudice, to those causes of action caught me really by surprise. And I'm still kind of processing it. I read the entire 132 pages, kind of just zipping through it to try to get on a live stream. I'm going to have to sit with it for a couple of days. And like my message was to people that are supporting Baldoni is like, yeah, it sucks. It feels like a loss. It's a gut punch for sure, but it's by no means the end of the litigation. There's still so much to talk about, and all of the issues related to fraud and defamation he could still potentially use to defend himself. He may. I'm not sure how he'd be able to do it with respect to the remaining causes of action, but everything is still at play. I mean, I'm just like you guys. I'm very curious about how 47.1 damages are going to apply now that he essentially has no ability, since discovery is not complete, to add, I guess, facts to the defamation claims to maybe bolster them, to maybe insulate them against damages. I'm not sure how that's going to work. Maybe for that reason alone, I thought that at the very least he might be able to at least add on to the defamation cause of action. So I'm surprised mostly by that. Not that they granted the motions, just that as they were as forceful as they were.
Yeah.
Hey, Lauren, what was, you're on top of this stuff, and I don't know how you're so on top of it. You're like in the middle of the night in Australia and you jump on this thing, but what was your first gut reaction to it? And now you've had some time to process it. I mean, what do you see as the path forward here for those that support Baldoni over Lively in this matter going forward?
I think like one of his probably biggest concerns is obviously going to be like clearing his name from the sexual harassment, accusations and stuff like that. So I'm not totally disheartened that that's not going to work out for him, because I know he can still defend himself. I think as far as this ruling goes, you guys know I'm not a lawyer, so all my stuff is like very much like public opinion, layperson type of thing. But I think it made sense, and I know a lot of people don't like that because I know there's some pretty strong opinions about the judge and all that. I don't really feel like anything negative towards the judge. I read that obviously, and it made sense to me. And then of course Omar explained it a little bit more, and it's still, I didn't really see anything improper here. So I feel like there's just a lot of heightened emotions right now, and I think that that's making it kind of difficult to see the ruling objectively. But I'm not totally disheartened for Justin. I think that it's important just to remember that this does not mean that he sexually harassed anyone or anything like that. So that's kind of where my head's at.
Yeah, I think I was surprised that the judge didn't at least give Baldoni a chance to amend with regard to the defamation against Ryan Reynolds, because I think that statement that Ryan Reynolds made that Baldoni was a sexual predator, I mean, I think that went a little far. And I understand what the rationale was, the judge when they're making the order, but it just seemed like he should have at least given them one more shot to try and fix that up or restate it. And I was a little shocked by that.
What are your thoughts on that, Omar?
The judge's reasoning was basically like, they didn't do enough to plead that, like, what if Ryan Reynolds just believed his wife and on that basis believed that he was a sexual predator? Like, how do you plead against that? He's literally claiming that he's not guilty of those causes of action. It was harsh. It's an impossible task. I know that some of the case law, just reviewing it from these 12b6, even indicates that, look, you're not going to have, the all of the evidence, especially for some of the nature of these claims. You could guess on the motive, you could speculate on things, but if you're forced to the very outset, just put all of your cards on the table when you don't even have the full deck, how could you possibly prevail on a defamation claim? And I think that what I've always been saying is there's no chance they're just going to outright dismiss it. I always had faith that they would, at the very least, let it get to the jury and they could at least figure it out. I thought he pled enough facially to at least survive a 12b6. Discovery still ongoing. The case law seemed to suggest that you should be forgiving for a defamation cause of action when evidence may be scant at the beginning of litigation. So to just outright throw it out altogether, that's I disagree with it. I don't understand it. And so it's going to take me a couple of days to kind of let it sink in, and maybe I'll have something smarter to say about it then. But for right now, I'm at a loss.
Well, they can still bring the tortious interference claim, which I don't know if they should, but on the other hand, maybe they should. I mean, this whole idea that what Ryan Reynolds said effectively got Baldoni fired from WME, it seems like there's still something there. I mean, any thoughts on that, Lauren, in terms of, because you know a lot about the facts of what happened there.
Isn't that's one of the things that's still kind of on the table? Is that right?
It is, yeah.
Yeah. Well, I feel like if he, again, I don't really know the ins and outs of the legal process here, but if he can, prove that he actually said that, I'm assuming they will ask the person who was spoken to. Is that how that's probably going to go?
Yeah.
If they can, prove that he said that, I feel like that's a pretty big deal. But, I don't know if this is going to go the way of, I know there was that reporter for the Daily Mail who had recently done and I've been out here, so I actually don't know too much about this, had done the affidavit, I think it was, that said, no, nobody told me, that he sexually harassed anyone or sexually assaulted anyone. And so that didn't really go the way that was expected. So I'm kind of holding out a little bit of judgment there, I guess, just because I'm like, well, I need to know what was actually said, or what does this person say that Ryan actually said to him? Not that I don't believe it. It's just like I really want to make sure that I'm not jumping into any conclusions there. Not that I don't believe that Ryan said anything terrible, but I just don't think that I'm really I wasn't there, so I don't know, and I can't see that this is not in the text message. Is like that huge exhibit with text message evidence and stuff like that. This is kind of like something that was said to someone else. So I kind of want to wait and see what that guy has to say.
But assuming it was said, wasn't there some evidence from I forget the agent at WME,
Ari Emanuel?
Yeah, wasn't there some evidence Ari Emanuel admitted that he did fire Baldoni because of?
There was a statement to that effect, I think.
I was thinking of the other guy. So I was thinking of Justin's agent, but Ari Emanuel, he went on that podcast, right?
Yeah,
he said
didn't it disappear? Like the podcast, stopped recording or something.
Yeah, and then somebody else had it. So
yeah.
But yeah. That's true. That's true. I've actually forgot about that. Sorry. There's just been so much stuff.
I know there is so much. It's hard to keep it straight.
Yeah.
There's this lady one of my friends, Anita, she came out of the Reddit world of, talking about this case. And she came on my show and she advanced like all of these crazy theories about how Ryan Reynolds and Blake Lively has this conspiracy and they like were motivated to steal the movie all along. And she comes on my show and me and her, like, we go back and forth. And I'm like, okay, but Anita, you're not going to just be able to stand up there and just like spout off for 2 hours your whole theory. Like, how is all this stuff getting in? And I think it just gets to the heart of, there's a lot of meat on the Baldoni complaint that is hard to comprehend. And I think that some of the stuff the judge was saying, was reading between the lines, is like, you guys are saying a lot of things. And a lot of it is like spread through these 225 pages in a 168 page exhibit A. And I'm not just going to go through it and try to parcel it all out for you. You have to like make it clear to me. I think the hardest exercise with this case is everybody suspects that there is things going on. The question is, how do you connect the dots without having all of the evidence that, yeah, this was a fraud and this was a defamation? And again, I'm flabbergasted that they are not going to allow leave to amend on those causes of action. Nothing, because what he literally said was, it's going to be futile for you to amend the complaint because there's nothing that you're going to be able to do to cure the defects.
Right.
And some of that I was just confused by that because I felt like there was a framework for stuff to put there, and all we had to do was fill in the gaps. And we're going to fill the gaps with the discovery. But we're not even going to get an opportunity to do that. I know that Anita, she comes on my show regularly. She must be devastated by the way that this is written.
Well,
I haven't even talked to her yet.
I think there's a lot of people out there that are devastated by this, and I think they've attached their emotions to this case. Many of them have been victims of this type of behavior, and so all I can say is stand firm. I mean, these cases, this is how cases go. In fact, Omar, Keith, and I were talking about our experiences. I know you're a true trial attorney as well. I know you've had to lose cases. Every good trial attorney has lost cases. That feeling when you lose, I can't compare it to anything else. It's the worst feeling in the world, and I can't sleep for days on end, and I become a zombie, and I keep questioning everything I did in the case. And when I win, it's not like, yay, I won. It's like, oh my God, I won. Yes. Okay. And now I can move on to the next case. What's your experience with that?
I'm devastated for like months. I mean, it just stays with you. Like, you try not to be, and you become, I don't want to say callous because callous is not the right word, but you're right. There's cases that I've lost where I'm still not over it, and there's still like, you'll have dreams, like you're making arguments and you're still arguing the case in your head. And it just never goes away. And then when you win, well, you were supposed to win. So you never praise yourself for the wins. You always beat yourself up over the losses. It takes a lot out of you. Like, I heard one of my mentors told me that, look, you only got so many trials in you because every single one of them
takes a bit out of you.
Takes a part of your soul, and you're not getting it back. And so look, you fight as hard as you can. And then when you'll know when it's over, and when it's over, it's time to get out because you're no longer going to be effective.
So I had a colleague when I first started practicing, Omar, tell me that you get 20 good years, and then everything after that just kind of trend down. So I'm at 20 years now. So I think the and Lauren, when are you starting law school? That's the question I want to know.
Oh man, I thought about it a while back, but it didn't work out. I didn't want to move away from home again. And then there was one school that was like within reasonable commuting distance, but I didn't get in. So I was like, I'll do it. I'll reapply next year. And then COVID happened, and then I just never did. So I don't know, man. I feel like that would be a pretty big commitment at this point in my life. And I like doing stuff like this. So it's hard to, I'm thinking about it for another year, but I don't think it's going to happen.
Okay. All right,
how long have you been doing YouTube, Lauren?
A little over a year.
Oh, okay, great. Wow, you're doing really well. That's not a very long time.
No, I mean, I certainly didn't intend to start a YouTube channel where I talk to people. I was doing like bad Fortnite videos. So it was I don't really know how this happened.
And then you two have been collaborating quite a bit. I've been seeing you guys going on each other's shows a lot. And then you go live. How do you both go live on each of your channels at the same time? We can talk about that later. But
Yeah. It's easier
Technical
than you
issues.
think. But
Okay.
yeah, we dual stream. Like there's a way where like I'll join her stream and then she'll allow me to stream to my channel, and then that way we got 2 different channels.
It's so
It's actually
interesting.
easier if you just show up at his house. I tried that too.
Oh yeah, she was over my house not too long ago. She's coming back this weekend on her way back from Australia.
Omar, without telling us the exact address, where do you live?
Oh, I live right on off the 15 and Sierra, like headed towards Vegas, like at the foothills of those mountains over there.
The Cajon Pass?
Yeah. Well, not exactly in there, like on the border of closer to
What
like
city-
Victoria
what-
Gardens, Rancho Cucamonga,
Okay.
San Bernardino, where all those things converge. It's basically where I'm at.
So Keith and I, when we started our practice, we were in Riverside for many years.
Yeah.
And then we moved to Ontario off Concourse for a while.
Yeah.
And then we just basically, we came down to San Diego, and we were kind of in a couple places around the state. We were up in the Bay Area for a while, but we're in your old stomping ground. So
Yeah. So you guys are in Riverside right now?
we're in San Diego now.
Oh, you guys are way farther down.
Yeah.
Yeah.
But
I remember
we loved
once
Ontario.
I thought that you were in Redlands, like maybe 15 minutes down.
I was in, that's where I started my practice, was in Redlands.
Oh, I see.
Many years ago. Yes.
Yeah. Well, it's significantly different being in San Diego. More like a 2-hour drive.
Yeah, it's a little bit of a drive, but
Yeah, but beautiful out there. I'll tell you that.
Yeah. Where Lauren, are you? We're just, feel free not to disclose anything, but where do you live?
Florida, outside of Jacksonville.
Oh, nice. Okay, I've been there. It's a pretty area. I like the trees there.
Yeah, I mean, I grew up there, so I've been there most of my life. I was briefly gone for school, but that's about it. So.
Ah, nice.
So should we see if producer Eric, do you have any questions that are coming
Yeah, I
in?
gotta jump back on here. I gotta make it like a not as cool of a Brady Bunch sort of thing now. But here's Leanne. I know Lauren, you've worked with Leanne a lot, like on
yeah.
videos and Twitter
Yeah,
and
she's
stuff
great.
like that.
Mhm.
Yeah, she says, didn't they say the tortious interference against Reynolds was out and only against Lively going forward? I don't know how much you guys may know about that, but seemed like a poignant question.
I mean, I'm looking at the conclusion. It says only the allegations relevant to the claims of tortious interference with contract and breach of implied covenant. It doesn't say relative to only Lively or Reynolds. So I think it's probably the whole claim against whoever it is it's against. So as of right now, I would say no. But like Omar, I haven't fully sat and digested this order either. It's 132 pages. So.
Okay, thank you. How about this? Because this is a question that, like, I myself, as someone who, may not follow as closely as everyone else, and we kind of show our graphic with the 2 cases. What happens if Blake drops her allegations? Like, is that possible at this point, or what?
So Omar, if Blake were to, at this point, because the defamation claim is, let's just assume it's essentially gone. If she were to withdraw her sexual harassment claim, how would that impact the case? And do you think that she would actually consider doing that?
I mean, not now. Why would she do that now? But if she wanted to drop the claim, she couldn't just do that without Baldoni signing off on it, because he's had to defend against these claims for one. He also has his 2 causes of action. And so it wouldn't just go away. The entire case wouldn't be over at her whims. Baldoni would have to agree to also drop the claims and, whatever claims he is claiming against her for having to defend the case. And that's pretty much the gist.
I tend to agree with that. I mean, I think people have been concerned that she's going to dismiss her sexual harassment claim. It's not that easy. I mean, I think that, first of all, I don't think she wants to. But secondly, even if she did, from a strategic standpoint, it's not that easy to do.
No.
And you need to get Baldoni to agree to it.
And like Omar said, why do it now? I mean, you just got a big win.
You're the
in
driver's
case.
seat.
Like, now's not the time to do that.
Yeah. Is there a question
well,
for?
I was kind of with. Sorry, what's that?
I know Lauren's got to run soon. Is there a question for Lauren that we can tee up for her?
Oh yeah, I got like 5 more minutes.
Hold on, let me.
It's kind of cool to see Eric on camera, by the way. I always hear him in the background.
Yeah.
Well, we're all in our studio there in our office, and our audio is all linked up. And it would be useless for me to normally be on camera because, like, people have probably seen I'm just like scanning the comments, and just probably looking psycho. So yeah, now when we're remote, I got to come on to do the questions and things like that. Here's
So
one. This might be.
I
So,
do have
go
one for
ahead.
Lauren if you have one as well, but I do have one for Lauren, and
Yeah.
that is, as a layperson, you're more of an expert on this case than I am. There's these comments that Judge Liman, has bought and paid for, and that he's got a brother in Hollywood, and no wonder, the decision went this way. What are your feelings about those kind of comments? Do you think those are valid comments? Do you share those comments? Do you think that those comments are a bit over the top?
I mean, I personally, I don't really subscribe to that belief. I don't think that the judge is biased, but I understand where people are coming from, and I understand there's a lot of distrust in the systems these days, especially just like, and I don't talk politics, but just like with a lot of the political issues and stuff, I can see where people are just at the point where they're just like, well, now I don't trust anything anymore, and I think that's kind of spilling over into this a little bit. I also see that people are talking about the brother being in Hollywood. Again, I don't think that that's really a direct enough connection here to make me feel like he's, in any way biased towards her. I really felt like the ruling it made sense based on the law and how he spelled it out. But I mean, I understand where people are coming from, so I don't want to say like, oh, people are being ridiculous, because I don't necessarily think that people are being ridiculous. I think that again, there's a lot of emotions attached to a lot of these issues. And it's really upsetting for a lot of people when they see something that they relate to not go their way. And also just some of the other stuff, like the brother in Hollywood and all that. I understand why some people are more suspicious of that than others. Just personally, I don't really feel that way. So
I really appreciate that response. I thought that was great.
Yeah.
Eric?
Yeah, I totally agree, because the headlines, like, now I kind of don't know what to believe, because people have really sleuthed out some really great things that ordinary people haven't been able to find. So it is tough. This is Bridget Valentine. I know she's watched us like from day one. She has a comment. She says, I can see Blake and Ryan come back with a $400 million claim against Wayfair. Want to bet? What do you guys think? Is that a possibility, or?
Omar, what do you think about that?
If they're going to come back with a $400 million claim against Wayfair,
Wayfair.
I mean, I don't know. I mean, they're already like, well, isn't it kind of late? They'd have to bring, they would have had to bring the cause of action already. At the same time that they brought I think they'd have some statute of limitations issues with that, or not statute of limitations. They can't bring another cause of action. They have to bring it all within everybody else's. What am I trying to say? What's the rule? Can't talk right
you have
now.
to plead it all at the same time.
Yeah,
and
plead
so it
all the
has to
same.
be
Yeah. So it wouldn't be
integrated
timely.
pleading. Yeah.
Yeah.
They
Well,
could get permission,
But what about
but they won't.
But what about 47.1? If it does apply, what do you, I mean, how much do you think, just taking a guesstimate, I know it's hard to do, but how much has Blake Lively's lawyer spent on defending against the defamation claim, which would arguably be tied to 47.1? So let's assume 47.1 is used for damages. But what do you think the attorney's fees are just to this point alone on the 47.1 issues?
I mean, I don't know, somewhere between 1 and 10 million.
Yeah, that's kind of where we're at. And then if you add treble damages to that, and Keith and I aren't sure how the statute will apply. Is it just the attorney's fees that are the treble damages, or is there also an emotional component for everything she's had to go through? I just don't know. I mean, this is a new statute, and I'm not sure how it's going to be interpreted.
Yeah.
But at a minimum, it seems like if it was $5 million in attorney's fees to this point in time, wouldn't we also see a $15 million treble damage claim likely under 47.1?
Well, yeah, I guess into that context, sure. But as far as the emotional damages, hasn't she already been prevented from presenting evidence of her emotional distress by virtue of earlier rulings?
I think she has. And
Arguably.
Keith, you talked about that the other day.
Well, yeah, we had that on the order, and it said, the judge said, I'm going to preclude any evidence of emotional distress. And I begged the question, do you mean just relative to those claims that were withdrawn, or you mean any evidence of emotional distress along the entire case? It was a little unclear to me because it was such a brief ruling, but that's what the ruling said. And so if that's the case, then yeah, it might be that it actually helps in the sense that it cuts down on her damages under 47.1.
Yep.
Yeah.
Interesting.
Anything else, Eric?
This one may be a long discussion here. I don't know if Lauren has the time or anything like that, but hey, how about this? This is a little systematic, but why isn't there a consistent, uniform legal system in the U.S.? The piecemeal, state-by-state legal differences only seems to hinder.
Oh,
I mean, it's
wow.
probably been that way for a while. Stuart, anyone want to give us a history lesson?
Oh boy.
Well, it
It
started with the colonies.
People have different lifestyles.
It started with the
Yeah.
Articles of Confederation
Yeah.
back in 1770s. And then you got the Constitution that comes along in 1789. And the states wanted to reserve certain rights to themselves.
Yeah.
And the health, safety, and welfare of its citizenry is generally left to the states. So each state, all 50 states, have their own legal system. Ironically, Arizona steals from California case law all the time,
Yeah.
and California statutes. But Omar, what are your thoughts on that? That's an interesting. It's an interesting idea. Could we have a universal law in the U.S., or are we always going to have 50 jurisdictions?
No, I mean, to the extent that you have state laws and federal laws, we're not supposed to be, the feds cannot police all 50 states. The states have autonomy to do what they want to an extent. Of course, unless you violate federal law, you have options to bring cases in federal court. And sometimes when you bring laws to federal court, because of geographical concerns, like, for example, in the Lively case, do we apply California law? Do we apply New York law? Where did the law take place? When did it happen? Who's going to be prejudiced and this and that? We ask different questions and try to apply the appropriate law. But the simplest way that I could answer that question is just that all 50 states have autonomy, and they have the ability to run things the way that they want to run them, as long as they don't run afoul of federal rules. And if it's a question of federal rules versus state rules, the federal law is going to win. In most cases, with few exceptions.
Yeah. Yeah. That's a long-standing historical reason why that happens, but I don't see it changing anytime soon.
Yeah.
All right, I gotta head to the airport. Unfortunately, I've been doing this since 2 a.m., so I'm gonna sleep good on the plane.
Thank you so much for joining us, Lauren. I
Great to
really
meet
appreciate you
in
taking
person,
the
Lauren.
time.
Yeah.
Sorry, I was so sleepy, but thanks for having me.
Have a good flight and
Thank you
get
so
some
much.
rest.
Take care.
See you later, Lauren.
Bye, Lauren.
Awesome.
How about this? Anything like, what's the deal with Jen Abel's case? Jed Wallace. Have you guys seen anything about that?
Nothing is. This order didn't have to do anything to Jen Abel's case. I mean, there's a case against Jen Abel for disclosing that information, but this order, I don't see that it ruled on any of the Jen Abel claims. And Jed Wallace is still fighting it out in Texas and in New York. He has a motion to try and transfer his part of the case down to Texas and New York State Court, or a federal court, which has not been ruled on as far as I know.
How about this? This seems like a question that I would kind of ask too, and thank you for this, Audrey Gibson. Can Justin file a whole new lawsuit? Is that even possible? And yeah, maybe to put a bow on it, and like what you guys had talked about before, what is the kind of avenue for Team Baldoni?
I don't think that they could bring, like, for example, I don't think they could just bring another fraud or defamation claim because of res judicata. You don't get two bites at the apple. And in the context of this lawsuit, those have been dismissed with prejudice. It means he could never bring it again unless it happens again some other way.
Yeah.
Yeah, I would agree with that. And Keith, as far as, Brian Friedman and team, once they get past the emotional hit here, what's their best path forward, strategically speaking? I
mean, I think the best offense is a good defense. So, I mean, I think the time is now to really gear up on the defense, look at what's going on there. I think right now they probably are gathering facts for that whole Van Zandt thing. And if they find the facts that they need to come in on a motion on that and try to exclude evidence, especially those text messages, that'd be huge to the defense of his case too. So I think there's still a lot to be done on the defense side that could be very helpful for him ultimately winning the case.
The only concern I would have about bringing the Van Zandt motion, I don't know what that motion would be, but let's assume there is a motion.
Yeah.
If you lose that on the tail of this, I mean, the people are going to start, saying what's going on with this legal team.
Well, that's why you need the right evidence. I mean, go out there and find the evidence that helps you with that. And then the question is, what do you bring and when do you bring it? And I think that's another strategic decision. But there's no right answers in litigation. You do the best you can. But I think that's where you really have to dig down and find. I mean, they should be. I'm sure they are. They're going to depose Jen Abel. They're going to depose Leslie Sloan. They're going to depose Stephanie Jones. I mean, all of these people are going to have to sit down and answer questions. And I'm sure that they have subpoenas out about all of their text messages and phone calls and emails. So they're going to find, you would think that they would find something in all of that.
And this is all in the context of them defending the case now going forward rather than prosecuting their own defamation.
Yeah. That, I don't think anything's changed there. I think that defense is the same as it's ever been.
Omar, what would you do if you were advising Brian Friedman? What would you tell him to do?
I mean, exactly that. I think you just you lean into the defense. You kind of lean into the ridiculousness of the SH claims, and you try to do your best. I don't think that anything changes like with what you're trying to prove evidentiary. I mean, a lot of the defense for the defamation claims and for the fraud claims could be applied or are applicable to Justin's defense against the SH claims, and so you lean heavily into that. You still do all the discovery. You're still going to depose everybody. You're still going to, you still have to finish the process. And so I'm not sure what this means in terms of how different the presentation is going to be at trial. You can't recover on fraud and defamation anymore. That's out. It's over. You have these other two causes of action. So try to expand on those as much as you can. Maybe try to get as much of the evidence in through those causes of action as you can to not give the impression that you're handicapped now by this ruling, which I'm sure they're going to feel that way for a long time. And then just, I think like Keith said, you're focusing in on doing everything you can to make the look, to make Lively's claims look ridiculous. For 47 point, and I don't even know how, when the 47.1 ruling comes in, like how are they going to award that? Do they have to wait until after trial? Or is that something that they're going to have to do before trial to figure out how those damages are going to play out? I have honestly no idea.
That's one of the things Stuart mentioned is that the judge might, even if they file the motion, the judge might just take it under submission, hold it in his back pocket and say, well, let's wait until trial before I rule on whether or not I'm going to grant these attorney's fees or not.
And
I just feel like, no, to your point, to that point, how do you defend against 47.1 damages without going through a full trial and seeing the full scope to, number one, figure out if maybe her SH claims are going to be deemed frivolous by a jury? I mean, I know that we don't get into the defamation stuff, but I think that before you're going to rule on those under 47.1, it would be prudent to do it after, if you have the ability to do so, after a full evidentiary trial. I mean, I don't know. Am I off on that?
Well, no, I think you're right, because the statute, I'm looking at the statute right here, and it says not only do you get, you get the attorney's fees, but you also get treble damages for any harm caused to them by the defamation action against them. Well, how do you determine what harm has been caused to them? It's like any other determination of harm. You would think it'd have to go some sort of evidentiary showing, which you would think would be in front of the jury. So it would make sense that even if they come in and refile their motion to get fees under 47.1,
we're not going to know the answer.
Yeah, and that the judge would hold it and say, "Well, let's see what the jury says, and then I'll rule." I think that's right.
Yeah, and then Omar, as far as you advising Baldoni to push forward to trial, I mean, obviously you go to trial if you need to, no doubt.
Yeah.
But what about settlement? Would you be trying to reach out to the other side, start a little diplomacy, or where do you think the time for that would be, if ever?
Yeah, well, I thought I made the comment earlier that I thought that where maybe I didn't see any evidence that Friedman was interested in the settlement before. Maybe that narrative has changed a little bit, because just the seas have shifted slightly, and you got to be able to read the direction of the wind, and maybe it gives them incentive now in light of this. And they're going to probably sit on this for a couple of days, but maybe they start reaching out and saying that, look, nobody's going to win with all of this. Maybe diplomacy is the action. Maybe you come up with like some joint statement that, look, lots of things happened. You said some things, I said some things, and we shake hands and, and go our separate ways, and maybe go do a joint venture for women's rights, maybe like a DV group. I know the way I could see the faces in the comments of people entertaining some kind of a thought like that. But I don't think that, well, I'll just say this. If there was ever a time where I've ever felt that settlement was ripe, now would be, I guess, the beginning stages of it.
Okay. Hey, Eric, now that you've had a chance to digest this stuff today, how are you feeling about this case?
I'm still pretty confused, to be honest, because like someone, I had put the comment up of someone being like, oh, can't she just drop her, what would happen if she dropped her claims? And I was like thinking, I was like, oh yeah, that kind of makes sense. When I just read it, like she kind of got this win and it's like, oh, let's get out now. But then when you guys said it, she kind of has the upper hand. I was like, oh, that kind of makes more sense now too. Yeah, I don't know. I'm still a little confused, but I get how it's narrowed and things like that, and what can't be brought up and what can. What about this one? Can any more claims be added that weren't brought up before?
Yeah, no, the answer is no. So the judge allowed them to amend only to those 2 claims, and to bring in any new claims would require permission of the court. So you'd have to go in on a motion to amend the petition, the complaint even further. The judge isn't going to do that at this point in time. I mean, I guess there's some strange realm where maybe that happens, but it's 99.9% chance not going to happen. So I think they're stuck with what they're stuck with now. These are the claims they have, and they either move them forward or they don't.
Maybe maybe like if there's some massive revelation of new facts and evidence that nobody knew about, and then you go to the judge and say, hey, we had no idea this was a thing, and maybe that would be the way that would happen. I guess technically it's possible, but unlikely.
Yeah.
Okay. Thanks, Omar. How about this one from Alexandra? If you weren't lawyers and knew all the legalities, do you think defamation is for the falsely accused? Defending yourself isn't enough?
I think that if we knew the defamation lawsuit by the perpetrator, the alleged perpetrator of sexual harassment, if we knew that that was valid and we knew it had support, I'm in full agreement with that going forward. The problem is that if you allow people to do these defamation claims, California is saying if you allow people to do these defamation claims, you're allowing them to bury the victim of sexual harassment, because you can bury them with litigation, with fees, court costs, emotional distress going through, discovery and depositions and trial. And so, Eric, you're an employee of my firm, and if you accused me of sexual harassment, which many people are wishing you to do, and then, I'm just going to assume, Eric, that because you work for me, I'm in a more powerful position than you. I don't know that I am. You may be a trust fund baby that has, billions of dollars, but I would be very angry if you accused me of sexual harassment. And I would come to my lawyers, all of them, all 10 of my lawyers, and I'd say, attack him, get after him, and bury him. And then your true claims of sexual harassment would never be heard. And then the worst part is Omar's not a lawyer, and he is actually somebody that knows you and sees what you go through. Then that gives a chilling effect to him when he wants to bring a sexual harassment claim, because now somebody wants to file defamation against him, and he sees what you went through and how they basically dragged you across concrete. And so I see both sides of this, but I do tend to fall on the 47.1 side now that I've had more time to think about it, because I think it does protect the most vulnerable people in our population that don't have assets, that don't have lawyers, that can't fight against somebody who tries to bury them. But that's just my feelings on that.
Like, even if you were to try to fix that rule, like, what would you even do? Like, I mean, it's really punitive right now to bring a defamation claim and then you lose, and then, okay, fine, treble damages is really hard. But I feel like there's got to be some kind of a mechanism to make a determination, like really early on, that, okay, like, look, it's reasonable. This is a reasonable defamation claim. It's not frivolous. There's some kind of evidence behind it, but even then would be problematic. I'm not sure how I understand the intent and the purpose behind 47.1, but I've also been on the other side where I have defended against frivolous claims of sexual harassment, domestic violence, sexual assault, and those kinds of things. I know I know what those people are going through because I've litigated with them. And it is certainly a thing that there is a good percentage of people, I don't know exactly what it would be, but there's certainly a percentage of people that are caught up in trying to defend against these claims that were falsely made against them. And they're in a predicament. And then if you had this 47.1, it's going to have the unintended effect of, making things more anxiety riddled for them. These treble damages where perhaps they shouldn't be. And that's never really been imposed before. It's not constitutionally supposed to be imposed. You're not supposed to be able to punish non-frivolous complaints. And yet here 47.1 kind of sort of does. And so does it make it unconstitutional? I don't think anybody's really had that discussion yet. And so the way that it's currently written, I certainly see the intent behind it, but I certainly also think that there's improvements that can be made if we just put some thought into it and ferret them out.
I feel like the treble damages is the most troubling part of the statute for me, just because you are punishing the mere filing of a lawsuit versus we do a lot of financial elder abuse that comes with double damages, or Penal Code 496 theft claims that come with treble damages. But that's because you're being punished for bad actions. You did something bad. And so that is
proven at trial.
Yeah, once proven at trial.
Right.
So it does bother me a little bit that this statute has treble damages. I almost wonder, though, when you're saying, you know, how can we fix the statute? There's a mechanism we use in California for vexatious litigants, where once somebody's deemed a vexatious litigant, they have, if they want to file something, they have to submit it to the court, and the court has to approve it before it's officially filed. And you almost wonder if you could have a process like that, where it's like
safe harbor.
Yeah, like here's my complaint. The judge looks at it and makes a determination as to whether I'm going to let you go forward on it, because then it's made at the beginning without anybody having to be subjected to, you know, punitive damages and treble damages and all that. And if it looks like there's some facts that are sufficient to allow the complaint to go forward, the judge allows it. And if it looks like there isn't, then they don't allow it. And so I'm just brainstorming here, just because Omar said, how would you fix it? That thought just popped into my head.
That's not a bad one. If you want to proceed.
Vexatious
litigant. Yeah.
Like somebody that's suing somebody all the time. But yeah, maybe it's like if you meet a certain threshold, then the judge will not the statute will not impose treble damages. But if it doesn't, and you still want to proceed, then treble damages and maybe some other stuff. But we're letting you know that it looks like a frivolous complaint.
I have an idea. What about tolling the statute of limitations on the defamation claim pending the sexual harassment determination?
You so wait until that trial's over, and then you can decide. That's not bad either.
And so if somebody loses their sexual harassment claim, now you have the option up for 6 months or a year or whatever to file your countersuit at that time.
Well, I always like my ideas better than your ideas, but that's actually pretty good. So I'm gonna have to give you that one.
No, I like that was a pretty good one, admittedly.
Omar, how long have you been doing this? On the Tilted Lawyer.
Facts again.
3 years. I've been doing it for about 3 years. I started much like you two, like just making like hey, this is how you file for a custody case, and this is how just trying to educate, make videos for my law firm, and then it evolved into the Tilted Lawyer. And so,
is Tilted due to gaming, some kind of gaming, or?
Oh no, I play chess. And so there's this thing in chess where you get on a losing streak, you're tilted. So
we got to play chess, Omar.
I'll do it. I'm down.
We should play a live game on here. That'd be awesome.
I would so do that with you. I don't even want to know what your rating is. I'm not going to tell you what mine is. We'll just figure it out.
You'll find out pretty soon.
Yeah, I don't know. I don't know if I'm good or bad. I'm decent.
What happened with that Magnus guy? Lost a couple there. It was a funny video.
No, he won. Well, he got mad. He lost to Gukesh.
Yeah,
and he wanted to beat Gukesh because he is right now the champion. But he's only the champion because Magnus retired a couple of years ago. And Magnus is still like 40 points higher rated than him. And so it's this really tough position. He was trying to salvage a draw and he just screwed it up. And he bangs on the table. And it was this whole thing. But it turns out he still ended up winning that tournament. So he's fine. Magnus is fine.
Yeah. He'll make it.
Maybe the best chess player ever, Magnus Carlsen.
By far. I mean, he would say Kasparov, but
I
don't know, man. The math is the math.
Yep, that's true. Anything else for us, Eric?
I think that's a pretty good stopping point.
Okay,
great.
Yeah.
Well, Omar, it has been a real pleasure to meet you in person, or meet you over there, or the video. We'll have to meet you in person at some point.
At some point, for sure.
Yeah, maybe Keith and I
it's been a pleasure. You guys are great, man. I love you guys. You guys are doing great work out there. Top-notch legal commentary. I love the whole setup and everything you guys have going on.
Well, we really appreciate you too. And really, when I can't sleep at night, I jump on your late night stuff. And it's just fun to listen to. So if you haven't had a chance to listen to Omar, the Tilted Lawyer, I highly encourage it. He talks about all kinds of things. Of course, Lively versus Baldoni being part of it, but he's a polymath. He kind of talks about a little bit of everything.
Yeah. Appreciate you taking your time, Omar. It was awesome.
Oh, it's my pleasure. You guys are great. Once again, thanks for having me on.
All right. We'll see everybody next time. Take care for now.
Take care.
All right. Y'all take care.
We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldavlaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.